So me as a real estate agent, I always look at the inventory and appraisal that's provided by the court to make sure that I am listing the property and getting as much or close to what the court wanted me to. Hi, I'm Miriam Cruz. I'm a certified probate and trust specialist, and I share everything you need to know about probate real estate. Normally when someone files for probate, they file for probate because a person has passed away, whether it's a family friend, their own family member, and the reason for filing for probate is to become the administrator or executor and administer the assets related to the decedent, basically the person that has passed away. Here in California, in Santa Clara County, the county that I mainly work at, people file for probate at the probate court near First Street, and they either walk into the courthouse and file for probate or hire a professional estate planning attorney that can file for probate on behalf of the family member. Normally when someone files for probate, the initial document that is required is the petition. And the petition has a lot of information that has to do with the decedent, the person that passed away, when they passed away, also with the petitioner, who could be the administrator or executor, and who they are and how they're related to this person. Normally, when people file for probate, they can either download the form online, sometimes walk into the courthouse, and if someone is getting help from an attorney, the attorney will gather that information and file on behalf of that person. So the personal representative who hires the attorney doesn't really have to do a lot of the legwork themselves. That's a benefit about hiring an attorney who's qualified, who can help out the family without having to put that responsibility on the family themselves. So the attorney will handle basically everything on behalf of the estate. When someone files for probate, after they get the letters of administration, they either become the executor or the administrator of the estate. Basically, they're the personal representative. But what that means is when someone becomes the administrator, the person who passed away did not have a will. So the person who becomes appointed is now the administrator of the estate and then can handle the assets and sell the property. On the other hand, when there is a will in place, the will has to do with the decedent's wishes. The person who files for probate with the will is able to become the executor, and at the time when they become authorized, they're able to sell the assets, including the home, with having that information related to the will. So they're the executor with a will, the administrator does not have a will. Normally the court will appoint someone, whether it's the executor or the administrator, once the court has seen the petition and has authorized that person to handle the assets. So basically the court, the judge, will look at this document, the petition that's either filed by the family member or filed by the attorney. And that's when the court decides if they're going to grant that petition or not. So the duties of an administrator or executor, which essentially is the personal representative of the estate, have to do with making sure that the assets are taken care of, distributed accordingly, disposing of any things that are inside the home, managing any bank accounts. If there's a car, it could be also disposing of that vehicle or transferring the name. If there's any other assets in other states, they might be responsible for that. But normally what the administrator or executor, their duty is to make sure that all the assets that belong to that person that passed away, the decedent, are taken care of and protected. And also that any homes that are out there, the title is transferred or the property sold and distributed accordingly to the beneficiaries. Basically in court, whenever there are multiple beneficiaries, the personal representative is required to let them know if anything is happening within the estate. That includes giving notice. So whenever we sell a property, we give notice to the other beneficiaries, and what the personal representative will do is work with the attorney or file it with the court themselves if they're going through probate on their own. This is called a notice of proposed action, which gives the beneficiaries 15 days to respond. So in real estate, for example, if we're going to sell a property, we let the attorney know that we're going to sell this property, that we're in contract, and the attorney will send out a notice to the other beneficiaries. And with that notice, they have 15 days to respond. If in any event they don't want the home to sell, or they want to buy it themselves, or they have an issue with that, they respond to the attorney and the court and let them know that they do not wish to proceed with the property sale. So this is the notice of proposed action. When selling a property through probate and notifying the heirs or beneficiaries, the notice of proposed action gives them 15 days to respond. I've never had a situation in which someone doesn't want the property to sell and will respond objecting to the sale, but it is something that's legally required. So whenever we sell a property, we give the attorney that information, and he or she will then give notice to the other beneficiaries that the property is going to sell. The personal representative in charge of the estate will give information to the court referee, again, which is assigned by the court, explaining what the assets include. Many times it's the real estate, that's where we come in, and that information that's provided to the court referee is then administered by the court referee to find out how much the property's worth. And this is based off the time of death. So if someone passed away 6 months ago, the court referee who's been appointed or assigned by the court will go out there, do their due diligence and find out how much the assets or the home is worth. The court normally assigns someone, the court referee, to evaluate the assets that belong to the decedent to make sure that it's really accurate. The court referee comes out to the property. They normally do a drive-by. Many times they don't go inside the property. They just do a drive-by and look at other comparables, because it is very important to understand how much a property is worth in order to evaluate and really come up with a number in regards to how much the estate is actually worth. And it's really important for us real estate agents to follow that, because the court is expecting us to sell and to bring as much money as they initially evaluated the estate at. So me as a real estate agent, I always look at the inventory and appraisal that's provided by the court to make sure that I am listing the property and getting as much or close to what the court wanted me to in their inventory and appraisal. As a personal representative, it's really important for the personal representative to manage and secure the assets. This includes also the real estate. So many times when people hire me to assist them with the sale of a property, they do have a property that's vacant or has a lot of things inside, or maybe the person passed away and they're not ready to sell the property because they don't have the proper authorization. So it's really important to secure the property, make sure that the windows are closed, that the neighbors are possibly monitoring the property as well, that it is insured. Many times people neglect or forget to have insurance on the property, and if there's theft or anything, they're responsible. So any personal representative that I work with, I remind them that once they are appointed by the court, they are responsible to make sure that all the assets in the estate are protected. This also means the bank accounts that are protected as well. So their responsibility as a personal representative is to ensure that everything is taken care of on behalf of the decedent. The assets related to the decedent have to be well protected. That includes when we sell a property, ensuring that the property is sold for the maximum amount of money. So normally when I sell a property through probate, we do put it on the market, on the open market and the MLS. We rarely sell off the market because on the open market, we're able to get more offers and get more money for that property. So it's really important for a personal representative to work with an experienced realtor who knows about probate process and to ensure that the estate is maximized. When someone's selling a property through probate, they are responsible to continue to maintain electricity, water, insurance, and other things like that. So it does become quite expensive sometimes if the property is not sold fast, but it is a responsibility of the personal representative to maintain the household, especially if we're going to sell the property. So we want to make sure that there is electricity and water in order to assist and show it to buyers when they come in through the property. So the expenses do still remain there until the property is actually sold, but the personal representative can provide receipts and other information to the state planning attorney to ensure that they're reimbursed. Many times I also pay for some of these expenses and get reimbursed when we sell the property. It is really important for the real estate agent, the personal representative that are working together to keep detailed records for the probate attorney. Many times these records are provided to the attorney and to the court, and this will be a part of the accounting process when the probate case is almost over. So it's really important that if the real estate agent has any expenses related to the property or the personal representative is spending any money related to the property, that they keep really good records. Probate here in Santa Clara County and many other counties around here in California, the probate case is actually public, so anyone can walk in to the courthouse and look at the file. So it's really important to have accurate records of all of that information. When you're selling a property through probate, it's extremely important to be transparent with the other beneficiaries and also with the personal representative to have an open communication. I don't mean really sharing confidential information or giving too much detail, but again, it is a probate public case, so it's important to be transparent, especially communicating with the attorney. The attorney has to be informed and has to understand whenever there's an offer that's been selected or when the property is off the market or will be put on the market, in order to ensure that everyone's on the same page. So I would say that communication is key when you're selling property through probate. There are many times that beneficiaries have questions or concerns. If I'm working with the personal representative who's a person or people in charge, whether it's administrator or executor of a probate matter, I normally work with them directly, and I do not give other information to other beneficiaries unless the personal representative has authorized me to do so. So me as a real estate agent, I do have an ethical obligation to my client or clients who have hired me. And in this case, it would be the personal representative or representatives of the estate that were authorized by the court. So I think it's really important to be transparent with everyone, but not give too much information to those people that have not been authorized by the court. Many times through probate, people decide to sell the house because they have to pay debts or there's multiple beneficiaries. Maybe one of them wants to keep the property, but the others don't, so they have to sell because they don't have the ability to buy them out. So there's many reasons why people decide to sell the assets, but the most common one is they don't need the property because the person who passed away lived there or they're out of state. So it's really important to work with someone who understands and is able to help the family. There are other situations in which maybe a family member wants to keep the property and they're able to buy out that personal representative or the other beneficiaries. So it's really important to communicate as to what the wishes are for the family and the beneficiaries. The personal representative of the estate will either have full authority or limited authority. With full authority, the personal representative is able to decide when he or she wants to sell the property after becoming authorized by the court. With limited authority, the court actually has to be involved. And if there is an offer that they want to take, they have to go back to court, the administrator or executor with the attorney, present that to the judge, and he or she will say yes or no. There's also a bidding process. So normally it is best to be authorized by the court and have full authority, because that gives the personal representative more control over the assets instead of going back to the court and getting permission from the judge whether or not to handle or sell these assets. Families can consider keeping the property or selling the property. It really truly depends on their goals and what they're considering. Many times families do decide to sell the property because they don't need the property. There's multiple beneficiaries and the family members are not able to buy each other out, or there is possibly a debt that they need to pay, maybe a loan or a reverse mortgage. Actually, reverse mortgage is very common in probate. So there's many reasons why the family would decide to sell or keep the property, and it really depends on their goals. Whenever someone's selling property through probate or through a trust, it's really important to work with someone who is familiar with the process, who understands the goals of the family, and who's able to work very well with the attorney if there is attorney involved. That includes preparing the home for the sale, whether it's cleaning it out, selling as is, staging, maximizing the estate basically. So it's really important to work as a team with someone who's knowledgeable, because overall the personal representative is responsible for the estate. So working with someone who's knowledgeable will allow them to know that the estate will be maximized completely. It's really important to market the property accordingly and to be very aggressive when selling probate real estate. This includes hosting open houses, emailing, texting potential buyers or agents in the area, Also using social media as leverage, and connecting with people in the area to see if there's anyone that's interested. Also, it's important to document any information related to the property. Many of the times, whoever's selling the property through probate was not living there. So it's important to have those disclosures in hand and to provide all of that information to any potential buyer to ensure that we maximize the results and we get the most money for the property. So normally when I work with someone who's going through probate and we sell the property, the funds are placed in a bank account, and that bank account is under the estate name. So the funds don't go to anyone directly right after we sell the property. It actually goes into a bank account. And the funds are normally not touched until the probate case is finalized and closed. For that, the attorney will file an accounting part of probate and will also submit an order in which the court and the judge then signs that order. So that's later on in the probate process. I'm not involved. I'm involved up until we sell the home. It's really important to keep records and to ensure that everything is documented so the attorney has an easy, smooth process when they close out the probate case. So if you're going through probate in California and need additional assistance, you're welcome to go to my website or reach out for more information.